Good afternoon, everyone. I'd like to welcome you to today's webinar, Litigation and Compliance, Hot Topics and Background Screening, which is presented by the legal experts at Seyfarth Shaw, LLP. As I said before, my name is Sarah Van Gilder, and I'm the Marketing Manager at Corporate Screening. We're very pleased to be able to present this webinar to you today. And just a little bit of housekeeping before I introduce today's speakers. During the webinar, you're going to be muted. There's going to be a question and answer session at the end of the presentation. So if you have a question that you want to ask, all you need to do is type it into the question box that's on your screen. Now I'd like to introduce you to today's speaker, Pamela Devada and Paul Kehoe. Pamela Devada is a labor and employment partner at Seyfarth Shaw, LLP in Chicago, Illinois. Pam leads Seyfarth's nationwide background screening, litigation, and compliance team. She's a national authority and firm go-to for all issues related to the Fair Credit Reporting Act, also known as the FCRA, background screening compliance, use of criminal and credit history, and electronic signature issues, as well as online and manual employment applications. A nationally recognized employment counselor, Pam has participated in numerous interviews, speeches, webinars, and trainings to employers on the subject of criminal history and credit checks. She counsels both employers, resellers, and consumer reporting agencies of background information on compliance requirements under the FCRA and related state laws. She develops procedures for appropriately handling high-volume national hiring needs and regularly litigates these issues on a single plaintiff and class-wide basis as an EEOC versus Kaplan Higher Education Corporation throughout the country. Pam also testified before the EEOC at a public meeting regarding the use of credit checks in employment in Washington, D.C. She's also a certified Lean Six Sigma Yellow Belt and was formerly an adjunct professor of legal writing at Chicago-Kent College of Law. She was also named by Law 360 as a 2013 Rising Star in Employment Law. Our other speaker, Paul Kehoe, is Senior Counsel in Seyfarth Shaw's Washington, D.C. office, where he is a member of the Labor and Employment Practice Group. Mr. Kehoe, a former attorney advisor to the Honorable Victoria A. Lipnick, Commissioner at the Equal Employment Opportunity Commission, focuses his practice on all aspects of employment discrimination law, including the development of strategies to prevent and resolve employment discrimination litigation under federal and state anti-discrimination statutes. While at the EEOC, Mr. Kehoe provided legal and political counsel to Commissioner Lipnick regarding all policy matters confronting the Commission, including final regulations and enforcement guidance documents, and regarding all aspects of agency business such as Commission-initiated litigation, systemic litigation, requests for approval to file amicus briefs by the Office of General Counsel, subpoena determinations, and field activities. He negotiated and drafted the Commission's enforcement guidance on the consideration of arrest and criminal conviction decisions under Title VII. So at this time, I'd like to turn the webinar over to our experts, Pam and Paul. Pam, Paul, it's yours.
Thanks so very much, Sarah, and welcome everyone. Paul and I are delighted to be here today to talk a little bit about hot topics and background screening and really how to stay out of litigation hot water and legal hot water, how to mitigate your risk. Real quickly, as a matter of housekeeping, this presentation has been prepared by Paul and I and our firm Seyfarth Shaw for informational purposes, should not be construed as legal advice and does not constitute legal advice or counsel. If you have questions about any of the things that we're going to talk about today, we'll be happy to get some information to you, but please understand that nothing should be construed as legal advice, and you should go seek your own counsel if you do have specific questions on factual scenarios. As Sarah said, and I apologize, our bios were a little bit wordy there, but Paul and I really focus in the area of mitigation and compliance areas with relationship to the EEOC and also the Fair Credit Reporting Act. As Sarah mentioned, one of the things that we spend much of our time doing is counseling employers and defending pattern practice lawsuits and Fair Credit Reporting Act class actions and single plaintiff cases all around the country. So today, what we really wanted to talk about were 5 main topics. What's happening in the world of background screening? We see and we do webinars often on different areas, and any one of the topics, frankly, that we're going to be talking about today could be its own hour or 2-hour long discussion. But we're going to hit on some of the new things that are happening, what has come down the pike in the last year, what do we see happening in the future. And those topics include ban the box, which is basically restrictions on when employers are allowed to ask about criminal history on the application. We've seen a huge increase in those that Paul's going to talk about. Some federal and legislative efforts on the use of credit history. There is no EEOC new guidance on the use of credit history, but we are going to talk about some pending bills and what we see maybe happening in that area. We're then going to talk very, very, very briefly on the EEOC criminal history guidance and how you can comply with that. Again, that has been the subject of many hundreds of discussions, and that is a much longer conversation. But if that's something that you're interested in hearing more about, or if any of these topics are areas that you're interested in hearing more about, I would urge you to contact CSS and tell them that. They certainly want to hear from their clients and want to be providing programming that is going to be beneficial to all of you. We're going to talk about the New York Attorney General's focus on background checks, specifically adjudication and hiring matrices. And then we're going to do an overview of some of the new areas that we're seeing employers being sued on under the Fair Credit Reporting Act. It's a lofty goal. We're going to try and get to everything with some room for questions at the end. Please use the question and answer box at the end, and if we see them popping up and we can work them into the presentation, we will, but there will also be time at the end. So without any further ado, I'm going to pass it to Paul to talk a little bit about some of the state and local law restrictions of ban the box.
Thanks, Pam. And just getting right into the nuts and bolts of the presentation, we're going to start off with a review of ban the box initiatives. As background, ban the box laws are popping up in various states and localities across the country. There's no federal law that directly applies to it, but what all of these initiatives are doing, and each are nuanced and has different carve-outs, but essentially what these ordinances or state statutes are doing is eliminating the criminal history question from the employment application. And to date, 4 states have done that, including Hawaii, and Hawaii statute is fairly old compared to the rest. But the trends are clear. More and more states are adopting these ban the box initiatives. More and more localities, whether they're cities or counties, are also adopting these provisions. Now, each of them is a little bit different than the next, but they are going to address when you can ask whether or not an applicant has a criminal background. Sometimes it's at the first interview. Sometimes it's after a conditional job offer has been provided. There are also restrictions on what an employer can ask. Sometimes there are narrow categories of what an employer can ask about, i.e., is any screen going to be job-related and consistent with business necessity? There are other carve-outs that say if you're prohibited from hiring a certain applicant into a certain position, then you can ask those questions as well. There are also different areas in each of these statutes as to how far back you can ask. Some are 7 years, some are 10 years, some have no time limit at all. And this kind of ties us back to the EEOC and the criminal background guidance that was adopted in 2012. And as somebody who was there and negotiating it, I can tell you that it is a lot better than it could have been. Could have been a whole lot worse. And in fact, the EEOC was considering adopting just a straight, you can't go beyond 7 years when you ask a criminal background question. Of course, that didn't come to fruition, but the EEOC did recommend that the question not be asked on an application because it views the question and an employer's response to the question as a barrier to employment. And the EEOC certainly believes that if the question is asked later on in the process after an employer has already invested some amount of time in the applicant, then the employer is more likely to overlook any youthful transgressions that that an individual may have partaken in earlier in their life. Now, I should say, these issues, they are forever changing. Just late last week, Baltimore, Maryland, the mayor of Baltimore adopted a ban the box. So these issues will continue to change over and over and over again. And it's very important that you reach out to your counsel in order to make sure you're up to date and fully cognizant of the nuances in each of these aspects. Next up are federal initiatives restricting the use of credit history. Of course, much like criminal guidance, there is no provision in federal law that prohibits the use of credit history when it comes to employment applicants, other than some of the restrictions of the Fair Credit Reporting Act. But recently, Senator Warren out of Massachusetts introduced the Employment for All Act, and this would amend the FCRA to prohibit employers from using consumer reports for prospective or current employees that contain information about an applicant's creditworthiness. There are two exceptions in this bill. The first is where national security clearances are at issue and have to be obtained before an individual is hired for a certain position. And then other requirements by law that require credit background checks to be done. Now, interestingly enough, there's no job-related exception. Yes?
We're getting an echo on your phone right now. Did you change something on that? I'm sorry to interrupt.
Perhaps you need to mute your computer. If you go to your speakers and mute the speakers on your computer. Looks like there's some feedback coming through the phone.
My computer is actually on mute, so.
There you go. That sounds much better. I'm not sure what happened.
Okay. Nothing on my end, but.
No, I think it's all good. And real quickly, before we get to credit, one just real quickly thing about the ban the box issues is, these aren't going away. As Paul said, we see more and more of these. And so if you are struggling with keeping up to them and changing your applications constantly, especially if you have an applicant tracking system, we would encourage you to think about moving them later into the process because clearly what it sounds like is that these are going to change and continue to change, and it's very, very challenging to keep up with them. All right, so now we'll go ahead and move on to credit. Sorry about those technical difficulties.
All right, picking back up on the credit history information, the EEOC's position is that it really doesn't have a position on credit background checks. There was certainly an effort within the building to draft some criminal background, some credit background guidance in conjunction with the criminal background guidance, or at least at the same time. Those efforts have failed. So the only information we have from the EEOC happens to be 2 sentences on the website that you can only see if you're really looking for it. And the EEOC's position is that generally all of a credit background check should be avoided because they tend to impact more on minorities and females, though an exception can exist if obtaining the information is essential to a particular job in question. This is really on the back burner at the EEOC. If they were to adopt any sort of potential guidance document, it would look very similar to the criminal background check guidance that was adopted in 2012, which analyzes the issue under the familiar Title VII standards. And it's important to note, however, that if any potential guidance document did get published, it would severely limit the use of credit histories in employment. The EEOC is more amenable to the structure that Senator Warren introduced in her Equal Employment for All Act, which essentially doesn't have a job relatedness exception. I think the EEOC would take the position that reviewing an individual's credit history is never job related, even if it were for a CEO or CFO type position. Now, the states have not left the issue in a vacuum. 10 states have prohibited the use of credit background histories, and they're right here listed. Now, again, each of these laws is a little bit different, but each of these laws doesn't incorporate exceptions for job relatedness. So an employer would be allowed to run a credit background check for money handling positions or fiduciary positions, law enforcement positions, or managerial positions. Now, it's also worth noting that in Nevada, if you are a dealer at a table in a casino, that's also an exception, at least for the state of Nevada. So I think at the end of the day, the trend lines are pretty clear. In 2013, there were 47 bills in 26 states limiting the use of credit history. So much like the proliferation of ban-the-box statutes in various states and jurisdictions, this is clearly where the arrow is pointing, and many states are looking to curtail employers' use of credit histories in the hiring process.
And obviously the EEOC was very focused on this issue, and certainly Paul and I have had many discussions, and the fact that we were both a little surprised that the EEOC didn't bring to the front burner the credit issue. I think there were a couple reasons why after it initially didn't pass, which was there was pending litigation, and full disclosure, it is our, Seyfarth Shaw, in my case, EEOC versus Kaplan Higher Education, where the EEOC actually sued an employer alleging that their use of credit reports had a disparate impact on certain minority groups, specifically African Americans. The EEOC lost that case. They lost on summary judgment because of their expert. They had very bad lawyering, although then it went up on the Sixth Circuit Court of Appeals, and the judge very specifically said, look, the EEOC is trying to enforce this against employers when it has this practice in place just of itself, because the EEOC does run credit checks on a majority of their positions. Now, that being said, I don't think that that's going to dissuade the EEOC in any way, shape, or form, frankly, from looking at cases. There's still the EEOC versus Freeman case out of Maryland that is pending. That case dealt with both criminal history that we're going to be switching to in a second, as well as the credit history. That case was also lost by the EEOC, and Freeman Companies won summary judgment, and that case is currently on appeal in the Fourth Circuit. So we'll see what happens there. We believe strongly, again, it was the same expert in both cases, and they have some big procedural deficiencies. But the EEOC really believes that they have a fundamental underlying theory that employers' use of criminal and credit history does have a disparate impact. And so we believe strongly that they're not going to rest until they prove up that theory. So be on the lookout. If you're not doing credit checks currently, don't start doing credit checks. If you are doing credit checks, we would highly recommend that you narrow the scope of the positions to be in accordance with the 10 states, as Paul indicated, as well as the many, many more that are on the horizon. The EEOC is also very committed and concerned with the use of criminal history, and we talked about that briefly at the beginning. Paul and I have done multiple presentations. I would say it's probably in the hundreds, a little bit more than that now, since the EEOC criminal history guidance was passed on April 25th in 2012. So it's been 2 years now that we've had this guidance. Again, we could go into great detail about what it says, but from a very high level, you should know that the EEOC is tremendously focused on the use of criminal history and enforcing their guidance. Now, they would say that they're not enforcing their guidance. They're enforcing Title VII of the 1964 Civil Rights Act. However, certainly we have seen them not at all shy away from bringing not only investigations on commissioners' charges. So that's a little bit different than somebody brings a charge on behalf of an aggrieved party. But also we've seen litigation. In June of last year, the EEOC filed 2 lawsuits, EEOC versus Dollar General and EEOC versus BMW, specifically alleging that those companies' use of criminal history in the hiring process had a disparate impact or negative or disproportionate impact on certain minority groups, specifically African American individuals, Hispanic individuals, and men. And some of the hot topics we're going to talk about, like matrices, were crucial in them bringing that. Very, very high level, the EEOC absolutely abhors bright line rules. You will be low-hanging fruit and ripe for a lawsuit if you have a rule that says we do not hire felons, we do not hire criminals, for example. We don't hire anybody who's been convicted in the last 7 years, because the EEOC says that will create a disparate impact on certain groups because certain groups are arrested and convicted more frequently than other groups. They have reissued, if you will, the 3-factor test that was actually put forth in a Circuit Court of Appeals case called Green versus Missouri Pacific Railroad. And basically they say, look, employer, if you want to defend against a disparate impact case under Title VII for race discrimination, when you use criminal history, you've got to do some things. Number 1, don't have a bright line rule. Number 2, we need to look at factors like the nature and the gravity of the offense. Was it a misdemeanor? Was it a felony? Was it a crime against a person or property? The nature of the job that is actually being sought. What are the essential functions of that job? And the time elapsed since the conviction or the completion of the sentence. They have also specifically said, as Paul said, to recommend as a barrier not asking the criminal history question on the application. So what do you do, and what are employers doing? Well, we would certainly recommend removing that from the application and moving it later into the process. From a mitigation of risk perspective, the number of people in your potential class action or nationwide pattern of practice goes down substantially. Instead of asking, 100 people who apply for the position, if you ask after an interview, for example, or after a conditional job offer, now potentially you're asking 2 people. So it's going to be very, very hard, number 1, for the EEOC to prove disparate impact because the numbers just aren't there to prove the statistics. And number 2, it's going to be less of a potential liability. The third thing, and this is really the sea change from the EEOC's perspective, and again, we can go into much, much greater detail on this, is from whole cloth, they basically said you need to do a case-by-case analysis of each and every person that you're looking at. We call this an individualized assessment, and there's a list of a myriad of factors that the EEOC wants you to look at. It is very, very challenging for employers because employers, when this first came out, struggled with how in the world am I going to talk to each and every applicant when I'm already getting pressure from my business to hire people. So we have come up with some ways. To craft that. You should certainly go and talk to your legal counsel, and you should consider what you need to do when looking at the EEOC criminal history guidance. It's not going away. It's been here for 2 years. The EEOC is litigating on this, and we would say, we would certainly be remiss if we didn't say, even though it doesn't have the full force and effect of the law, because it is guidance, the EEOC can make your lives very, very challenging and very expensive if you choose not to comply with those. So what should employers do as best practices for complying with all the things that we just talked about, especially with the EEOC criminal history guidance? Review your employment applications for Ban the Box and the EEOC. Think about when you're going to ask about criminal history, if you're going to ask, which we do think is a good thing, especially for falsification purposes. How are you going to do individualized assessment? One of the ways you can do that is having a centralized background screening rule. So think about that and consider that. Many, many large companies, Fortune 50, Fortune 100 companies have decided to, even though it's very challenging, they have shared services to do centralized processes so that they can be consistent and not then get an individualized, a disparate treatment claim, for example. Make sure you have a background screening policy. Look at your procedures. If you do have a matrix, look at that. And we're certainly going to talk a little bit about, in our next section, hiring guidelines and adjudication matrices and what both the EEOC and the New York Attorney General have said about that. And then last but certainly not least, the CSS might be able to help you with getting some information. One of the things, the factors that the EEOC says to look at is a person's employment both before and after they have been convicted as a mitigating factor. And if you're doing employment verifications, for example, with corporate screening, then they could certainly help you gather that information. Again, that is a very, very condensed version of the EEOC criminal history guidance, but it is a hot topic, and it is still very, very timely and apropos, because we are seeing more increased litigation, not only from the EEOC, but some private employers as well.
And Pam, if I could just hop in on 1 second here on one additional point. Even if you as an employer have the the perfect criminal background check policy, it's not necessarily going to be a get-out-of-jail-free card with the EEOC, because what the EEOC, somebody is going to come in and file a charge, and it's probably only going to be one person who files the charge, but the commission is going to open up a company-wide or nationwide investigation into the hiring practices. And while the EEOC is losing currently at litigation, it's still costing a lot of money during the investigation process. And even a perfect policy isn't going to end that investigation. The commission is always going to investigate to see how the policy itself was applied.
That's an excellent point. And we're very, very lucky to have Paul here talking today, because he was, he has downplayed it a little bit, but he certainly was instrumental, obviously, as were all of the commissioners, but especially Commissioner Victoria Lipnick, with whom Paul works at the commission, at making the guidance much more employer-friendly and management-friendly than it really could have been. And so understanding some of the back and forth that went on, and some of the things that we're able to get into the guidance to help employers, I think is tremendously crucial as well. The EEOC and also the New York Attorney General have been very focused on the use of criminal history, and one of the ways that they have been focused, and this is our next section, is talking about adjudication and hiring matrices. And here's what I mean about that. A lot of companies have background screening policies that also have an adjudication or hiring grid. And on one hand, they'll have, for example, a list of crimes, and then maybe they'll have a date range, and then they'll have a grade. And those are tremendously helpful things to be consistent. The good news on those is that you can bake in the green factors, if you will, the nature and the gravity of defense, the timing. You can even have different matrices for different positions, which we would highly recommend. But the New York Attorney General has brought to light, really, a law in New York that for many, many employers they were not really following. And basically, New York Article 23 of the Corrections Law specifically states that an employer really should not be using criminal history unless it applies the specific 8 factors to determine whether or not there is a direct relationship between a specific job and a specific offense. The 8 factors are listed here. You will, if you have seen the individualized assessment factors under the individualized assessment guidelines with the EEOC, they're very, very similar. So, for example, and frankly, we think the EEOC borrowed from that idea. You got to look at the specific duties and responsibilities. You need to look at whether or not the conviction is job-related. How long has it happened? Was it 10 years ago, 15 years ago? Was it 2 years ago? How old was the person? For example, were they 18 and a stupid kid, for lack of a better word, or should they have known better? The seriousness of the offense, rehabilitation, for example, and both the public policy of New York of hiring people and getting back people who have had missteps with the criminal justice system, but also the safety and the welfare of people in New York. The reason we bring this up is because we have seen a lot of interest by the New York AG and a lot of interest by the EEOC when companies use these hiring guidelines. And what we've really seen is if you have a hiring guideline and you are in New York or have anybody in New York and it has a fail or an automatic disqualification, the EEOC would say that that's a bright line rule, and then you're not applying individualized assessment. And the New York Attorney General would argue that you are not following New York Article 23A and applying the direct relationship factor test, and therefore you are violating a statute. different than violating guidance. This is a statute. It has very specific private right of action, and you have to be really careful about that. So that being said, be very, very careful about your use of ineligibles, fails, do not hire, bright line rules, as the EEOC would specifically argue that they might be. Matrices very, very good, comma, when used the right way. It's really the takeaway from that. We're now going to switch gears and talk specifically. Now we've talked about some of the ancillary issues with regard to hot topics and background screening, and now we're going to talk about the Fair Credit Reporting Act, which for those of you on the phone who have never heard of that, you should, because if you do background checks, it is the statute that specifically regulates all individuals and all companies in the background screening, I would say, function, which is the end users and employers who request the information, consumer reporting agencies such as corporate screening who provide the information, furnishers who have the interaction with the applicant. And so we're going to dive into some of your employer responsibilities and then talk about really how these are being challenged and what we see with regard to litigation. Paul?
Thanks, Pam. And yes, that's exactly right. The first half of the webinar was kind of, what to do with the information that you get. Now we're switching gears a little bit to the Fair Credit Reporting Act, and that's going to essentially govern how you get the information. So this is really an introduction slide, and I'm going to blow through this pretty quickly, but an employer essentially has 4 duties. There must be a permissible purpose before an employer, or frankly anyone, obtains a background check report from a CRA. There also has to be disclosure and authorization forms signed by the subject or the applicant in most employment arenas before getting the consumer report. An employer also has to follow the 2-step process before taking an adverse action based on information that's contained in the report. And then finally, the employer will have to certify to the consumer reporting agency like CSS that they have essentially followed all the laws and all the nuts and bolts in obtaining and using the information. So without further ado, we're going to jump right into the permissible purpose. So before running a background check, a person must have a permissible purpose under the Fair Credit Reporting Act. And the statute itself lists about a dozen or so permissible purposes. For our purposes here, the 2 most important ones are employment and at the written direction of the consumer. Others include, by a court order, or if you're involved in a credit transaction or underwriting insurance. But what we're going to focus on is an employer running a background check with a consumer reporting agency for employment purposes. And essentially, this is also going to include volunteer or independent contractor type situations. They could also fall under the at the written direction of the consumer permissible purpose, but the FTC has opined that employment purposes encompasses scenarios involving volunteers and independent contractors as well. At the end of the day, if you don't have a permissible purpose to run a background check like this, then you essentially can't do it. It's kind of a chicken and the egg problem. You really need to make sure you have a permissible purpose before jumping into asking for this type of a background check. Pam?
We've seen tremendous amount of litigation. We saw a little bit on the permissible purpose issue, and there's still some arguments in some other contexts. For example, if you're a school and you are getting, you are running checks on students, for example, to go into nursing or other screening programs. We've seen some litigation on that. The key is you can absolutely do it. You need to get the written authorization, and the issue is whether or not that's a permissible purpose of an employment, and reasonable minds can differ on that. What we've seen almost the most litigation in any situation under the Fair Credit Reporting Act against employers is really twofold. It's their their responsibilities in getting a disclosure and authorization, and their responsibilities in adverse action. With regard to disclosures and authorization, the Fair Credit Reporting Act is very specific that if you are using information for an employment purpose, you must have a standalone document that consists, quote unquote, solely of the disclosure that discloses the fact that a background check will be run. Now, there's additional state law implications and requirements. You'll see here, these are some of them on the bottom of the screen. And that doesn't sound very complicated. But what has happened is that the statute itself and the FTC have then said, well, you also need to get a written authorization from a person. It's a written signature, basically allowing you to get from a third party, like corporate screening, a background check. Again, doesn't sound terribly complicated. But what we're seeing a lot of is challenges to what the, quote unquote, solely the disclosure is going to be. So, for example, we have seen many, many challenges with regard to allegations that if you have a release of liability in your disclosure form, it does not meet the requirements. And indeed, there are two courts that have said that. There's the Singleton versus Dominant Pizza case and the Reardon versus Closet Maid case. There's also other courts that have held that the release of liability doesn't make that big of a difference. But I would strongly encourage you to take a look at your forms, because these are what class actions are made out of. And when we talk about damages provisions in a few minutes, we'll be able to let you know why this is so important. Really, the Fair Credit Reporting Act, which I've been dealing with for about 14 years now, is the new wage and hour cases. It's the new Fair Labor Standards Act as it comes to collective actions or class actions. So you have to be really, really careful about this, because the damages are tremendously high, or have the risk of being tremendously high. So the authorization and the disclosure form itself can be combined. However, we are seeing challenges when there is any piece of extraneous information whatsoever. So, for example, if you've got state law information in there, we think it's certainly appropriate. However, there have been challenges to that. You've got a release of liability. If you've got other, quote unquote, any extraneous information, you really want to make sure that you are reviewing your disclosures and authorizations at least annually, because the law and the case law on this is changing. One of the things that in a class action people argue is that you've had willfulness, reckless disregard, and so you want to make sure that you are reviewing this, so you can say, look, we're reviewing these on a yearly basis. We're not reckless. We're trying to get correct forms. You certainly absolutely can use sample forms from your background screening provider, for example, corporate screening, but please understand it is solely your responsibility under the law to make sure that you have an appropriate disclosure and authorization. To be cautious about that. The next topic, very similar to disclosures and authorizations, is electronic signatures. And one of the concerns is, can you have a signature that's not a wet signature on your authorization form? And the FTC has said absolutely you can. We've seen some challenges. It's been a couple years now. We've heard some rumblings that there may be more. But basically what you want to make sure of is, if you have an electronic process, that it complies both with the e-Sign Act and also that it complies with UTA, which is the Uniform Electronic Transactions Act that 47 states have signed on to. You need to make sure that you do this so that you can defend against any challenges to it. There was some private litigation that was happened a couple years ago, Pitt versus Kmart, and one of the things that occurred then was a challenge to the use of e-Sign, but that case went away. The next part of biggest litigation is adverse action, and I'm going to let Paul take over for a second on here.
Thanks, Pam. When we're talking about an adverse action, what we're talking about is, in the employment context, is the decision not to hire an individual or a decision to terminate an individual. Generally speaking, those are the two areas that we're talking about. So what happens when the employer receives a consumer report back from a consumer reporting agency, and all sorts of alarm bells are sent off because a litany of criminal convictions or other adverse credit information comes back? Well, before an employer actually takes an adverse action, it has to provide the consumer with a copy of the consumer report, a summary of the consumer's rights under the Fair Credit Reporting Act, and a summary of state law rights that any state may have. So essentially what the letter that goes to the individual is going to say, in addition to having all these things, is essentially that we are considering not hiring you because of some of the information that came up in the consumer report. So what does the individual have to, what does the company have to do at that point? Because it can't just take the adverse action at that point. Essentially, the employer must wait, and the FTC has opined that an employer should wait at least 5 days before sending the adverse action letter in and of itself. And why is this? Well, it gives the individual an opportunity to essentially contest the accuracy of the report before the adverse action is taken. So let's say the applicant's name is John Smith, and something comes back with a murder conviction from John Smith that occurred, 5 years ago. And John Smith, the applicant, can call up the employer and say, hey, look, that is a different John Smith, that is not me, and therefore you should still hire me because, who knows, maybe the middle initial is off, or there's a date of birth discrepancy on the report. But it really provides the individual applicant just an opportunity to be heard, to say, hey, look, this isn't me, and the screen that you're implementing shouldn't apply to me. So many employers fail this by also contacting the applicant by phone before giving a pre-adverse action notice. And another flavor of that is there could be automatic notifications out of an applicant tracking system that is sent to an individual that that they're not going to get hired. This is going to be a big problem, and we have seen increasing litigation on these types of issues.
We call that the no good deed goes unpunished, right? I mean, most of the employers are really trying to do a good thing. Somebody's going to, for example, be hired, and then they're going to start on Monday, and it's a Friday afternoon, and they don't have their background check back. Or you get the background check back, and it's a problem, so you don't want the person starting on Monday. This is when the recruiters pick up the phone and say, hey, there's a problem with your background check. Recruiters should be very much trained that they should only be saying your background check is pending or still in process. We're going to need to move back the date, for example, and nothing about any indications there's any problem or any issue. Again, that's another reason to centralize the process so you can ensure the people who are going to be making those communications know what they can say and what they can't say. It's a very, very big problem, and we've seen a lot of new litigation on this recently.
Right, and the first question that the recruiter should be asked if any applicant actually calls and says, hey, can I start on Monday? The first question should be, well, have you seen your consumer report yet? We have sent it out to you. And if they say no, that's when you get into, oh, well, the background check is still pending, and call us when you actually get our correspondence. That will at least insulate the employer from telling somebody they're going to be subject to an adverse action before receiving the pre-adverse action letter. Now, what happens next? After the 5 days has occurred, an employer can send the adverse action letter. Hey, we have decided not to hire you, and this is the reason why. What must be included in that correspondence, in addition to whatever the adverse action is, employers also have to include the name, address, and toll-free number of the consumer reporting agency that furnished the consumer report, and a statement that the agency didn't make the decision, that the consumer reporting agency didn't make the decision to take the adverse action, and that it was the employer's decision, and that will insulate at least a little bit the consumer reporting agency from any potential liability. Now, after the adverse action is taken, the employer also has to provide a notice of the consumer's rights, and they can obtain a free consumer report from the agency within 60 days, and a notice of the consumer's rights to dispute the accuracy of it. As Pam touched on it a little bit before, these really are the new FLSA cases, and you kind of harken back to the early days of the wage and hour litigation. But we are seeing more and more of these type cases where employers and or consumer reporting agencies didn't follow the procedural requirements of the Fair Credit Reporting Act. And you know, these are cases that, you know, certainly some plaintiffs' counsel see as low-hanging fruit, and you know, because of the proof requirements in the Fair Credit Reporting Act and the rising level of sophistication for plaintiffs' attorneys, these are becoming more and more prevalent in the market. Moving on to our next topic of what an employer has to do, the fourth and final duty, the certification. So employers have to certify to the consumer reporting agency that the employer has distributed the required written authorization and obtained the necessary disclosures, and also has to certify that the information isn't going to be used in violation of any of laws or regulations, and that the employer will comply with the adverse action requirements. These are really, you know, the nuts and bolts procedural type safeguards that are included within the Fair Credit Reporting Act. Now, most of the certification requirements are going to be normally encapsulated in the end user service agreement that any employer has with a consumer reporting agency. But again, these are the issues that you know, can be easy to mess up, if you will, from the point of view of the enforcement agencies as well as the plaintiff's bar.
So why do we care about this? And you know, both Paul and I have made mention that there's increased litigation here, and really what we're seeing is huge increase, not really even on the individual single plaintiff cases, but on the class-wide, nationwide pattern practice or Rule 23A class actions. And there's two different types of claims that you can bring under the Fair Credit Reporting Act. One is a negligent noncompliance, and one is a willful noncompliance. For negligent noncompliance, the damages are going to be actual damages for the person, which is generally going to be back pay, sometimes compensatory damages like emotional distress information, but there's a split in the circuits on that, and attorney fees. We rarely see these. Why? Because there's not as much bang for the buck. The second type of case is when we see the class action. This is willful noncompliance, and the Supreme Court has ruled that willfulness must be proven by showing either malice or reckless disregard for the statute. And here's the kicker. The statutory damages under a willful noncompliance is going to be $100 to $1,000 per person. So gone in the negligent noncompliance where there's a class action and we can potentially fracture the class or defend against the class action by saying that there's individual damages. For example, here there's only one set of damages, and so we don't have that argument. The other thing is that attorney fees are also able to be gleaned, but more importantly, punitive damages. And here's the rub. The statute of limitations under the Fair Credit Reporting Act is the earlier of 2 years from the person knew or should have known, or 5 years from the date of the report. So when people ask about exposure for an FCRA case, basically it's how many background checks have you run in the last 5 years multiplied by 1,000. Then add attorney fees and unlimited punitive damages. And you'll see that that can get very, very, very expensive very, very, very quickly. Now, there are many ways to defend and to fracture a class and to set up appropriate disclosures for this. But really, you should be cautious about understanding all of the compliance issues. And we're going to end with some best practices and then open it up to questions. We talked at length about the disclosure and authorizations. Very, very quickly, review those annually, purge the information that is extraneous or could be deemed as extraneous. We believe, even though that the forms can be together, you should think about whether or not you want to have a disclosure, then a separate authorization, and a separate state law statement. Certainly, if you have a release of liability or you want a release of liability, it cannot go with the disclosure. Period, end of story. It can go with the application. It can go with the authorization, but not if the authorization is with the disclosure. And, you know, we talk about challenges to consider. You want to make sure that if you're using an applicant tracking system, they know what they're doing, they understand these challenges, they help you set up the most defensible way that you can. I very specifically like 2 pass systems, where somebody applies and then later in the process, perhaps after a conditional offer, they go through and they do the criminal history question and they do the disclosure and the authorization forms. You also want to be cognizant of the user experience. We hear all the time from our employer clients that the user experience is tremendously important to them. And so understand that you may need to change or modify the way that you do your process so that you can still keep those applicants and get that good user experience, but that you're also compliant. With regard to e-signatures, very quickly, we told you before, just make sure that you comply with UTA and e-sign. This slide, and for purposes of time, we're going to just go quickly so we can open it up to some questions. But this slide really talks about what you need to do for to comply with e-sign and UTA. You should definitely make sure that you have these reviewed by outside or inside counsel, because frankly, a lot of applicant tracking systems just don't do a very good job of covering those. So you really want to make sure that you do that. And certainly last but not least, with regard to some of the recent cases and the recent settlements, you can see these numbers here. Very, very, very large numbers. You know, you've got 2.5 million, 2.75 million, 450,000, another for $18 million. The number of damages goes up exponentially, and the larger a company you are, frankly, the more you are at risk, because there's an argument that you run so many of these checks, and you know, we're handling multiple cases right now where the process and the procedure is excellent, but it's one small, very technical minor issue where, you know, like Paul had indicated, the ATS system sends out an auto-generated email, for example, or at least that's an allegation, right? So if you do have that, make sure you shut those off. They're not going to be compliant with the 2-step adverse action procedure, because those automated emails don't give a copy of the report and a copy of the summary of rights and the right to the person to dispute. You have now, unfortunately, potentially violated the FCRA. So make sure that you review these. Paul and my contact information is up on the screen. And with that, I'm going to turn it over to Sarah. I know we only have 5 minutes left, but we'll try and get to as many questions as we can.
And I'd like to invite anybody right now to go ahead and type in the question in the question box if you have any. And I wanted to take a moment to thank all of you. I wanted to thank you, Pam, and you, Paul, for presenting today, and everybody who is on the call and listening to this for taking the time out of their day to join us. So I'll give it just a minute to see if there's any other questions. But if you, and I also wanted to throw out there too, as Pam said, there's contact information for both Pam and for Paul on the screen. And if you have any questions about that, if you don't get it down, you can contact us. I've got a question, first of all, would you please explain the difference between a disclosure form and an authorization form?
Sure, and that's $1 million question. But generally speaking, a disclosure form is when the employer discloses, we are going to be running a background check about you that may consist of XYZW, a criminal history, a social security check, education verification, and employment verification, and we're going to be doing that through a third-party consumer reporting agency, corporate screening services, for example. An authorization form is when the person actually authorizes the running of a background check. So it's a signed document, and it usually has language that says, by signing below, I authorize the company to do this. So it's more than a telling, it's a authorization or an acknowledgement saying that the person agrees to have this done, not just the telling that the checks might be run.
A follow-up question to that, can the disclosure be a part of the offer letter?
The disclosure cannot at all be a part of the offer letter unless it is a freestanding standalone document. And so, for example, you can put it in a packet of documents, but it needs to not be in the bottom of an application, for example, or not be in the text of the offer letter. It has to be a freestanding, quote-unquote, solely the disclosure is the language of the statute.
Another question, if we remove the box from the application, can we still have them sign the authorization form for the background check at the same time during the initial interview, or should this be done later?
So great question, and what I would say is with the increased litigation, the argument is you should only have people sign off on background screening forms and criminal history when you need them to. Because, again, if you only have the people who are going to actually have a background check being run have those forms, and there's something wrong with the form or challenged with the form, that's the scope of your class. If you have every single person who applies that then specifically looks at that disclosure form, arguably somebody's going to argue that's the scope of your class. Now, we would try and defend that and say, no, it's only the people we ran a background check on that would have standing. But why even mess with that? So we certainly recommend, again, without giving legal advice, to push it later in the process.
And then another question, could you please clarify, is Washington State, is it exempt or not from electronic signature laws or not legal to use yet?
Oh, good question. So Washington is one of the 3 states that does not sign on to UDA. They have a digital signature law. And so you just need to be very careful about what you're doing in Washington to make sure that you comply with digital signatures if you're going to be using electronic signatures there, although frankly there has not been a lot of litigation there on that.
And then this other, the last question is, does corporate screening provide a template of both forms to the client? And I can answer that. Yes, we do have them. We have copies of forms that you should have in a compliance packet. And if you don't have it, I believe it's available on our resources section, and I can get back to you on that for sure, letting you know where you can get some. If there are no more questions, then we'll end this. And right now, I don't have any other questions. Oh, I do show one more. To expand on Washington law, when you say be careful about how you use electronic signature, be careful how?
Really, that means go and talk to your outside counsel about what you need to do to comply with the digital signature requirement. Depending on what type of item you're signing, it depends on whether or not the law is going to comply. So that's a very factually specific question that you need to get guidance from your outside counsel or inside counsel.
It looks like that was the last question, and I just wanted to take a moment to thank everybody. As I had said before, thank everybody who took the time to listen to this, and thank you especially to both Pam and Paul for your time for doing this. We really appreciate it. So at this point,
thank you for having us.
Thank you, and everybody have a great day.